Welcome to Consented, a podcast by Usercentrics that delves into the world of privacy-led marketing. Each episode, we bring you expert guests from our partner network to discuss the latest trends, strategies, and best practices to explore how you can grow your business while respecting your customers' privacy. Are you ready? Let's dive in. Welcome to episode 7 of Consented. Today, we're going to be talking about the most important considerations for SMB websites to enable GDPR compliance. I would like to make a disclaimer that while we do have legal experts on this podcast episode, we are not giving legal advice, and please always consult your own legal counsel if you have any concerns. So let's get into it. Today, we have 2 very special guests who I'm extremely excited to have on the podcast today. We have Marcelo Treistman, who is head of policy team and in-house product and privacy counsel at Wix. Welcome, Marcelo. Great to have you. Would you introduce yourself a little bit to the listeners today?
For sure. Thank you for having me. And it's a pleasure to be here. I am... Just for the beginning, I am a Brazilian lawyer that is living in Israel for about 20 years, and I'm working here at Wix for about 13 years. I am a head of the Wix policy team that takes care of all the content moderation issues that we may have at Wix. We are a website builder platform, and we allow people to, upload lots of content. We may have issues with the content uploaded by our users. So I'm head of this team. And I am also a legal counsel in the team that handles the privacy and product issues here at Wix. So thank you very much again. And it's a pleasure to be here.
Great to have you. Thank you. And then we also have our very own Sara Kamph, who is legal counsel at Usercentrics. Sara, would you like to introduce yourself to the listeners today?
Yeah, sure. And thank you for having me. So my name is Sara, and I'm working as a legal counsel at Usercentrics. And I've been a part of the company for 4 years now. And I'm specialized in data privacy, data protection, and compliance. And yeah, I'm living in Denmark in a small city close to our office in Odense. Yeah, but happy to be here.
Great to have you guys. So I'd like to jump into the topic of how the privacy legislations have evolved over the years. And originally, I think that people had the idea that these kind of laws, such as GDPR, were more just for big enterprises, not really worrying about them so much for smaller companies. And I would like to hear from you both. How have you seen legislation change and evolve over the years from sort of privacy to data privacy?
So I think I can start this one. I don't know if to talk about the data privacy and privacy rights, it's something that we should go back a while ago in time. I don't know if it was the first regulation or legislation to talk about the right to privacy, but I think in my view, the most important text of law talking about the right of privacy is the Universal Declaration of Human Rights that it was enacted in 1948. So just to give you some historical background and context and why I think it's important to talk about it. So right after the World War II, the world came together to issue this Declaration of Human Rights and establish some of the most basic human rights that we know, like in this declaration, we have the right to life, the right to security, freedom of speech, freedom of religion, and of course, sitting next to these rights, we have the right to privacy. So in this declaration, the right to privacy was understood as a basic human right. Privacy is not a standalone right. We know that without the right to privacy, we will see the violation of other rights if we don't have a protection to the right to our privacy. In this declaration, in Article 12, we have the sentence that gives the protections to the right to privacy, but being more specific, back then, the right to privacy was something that was attached to the privacy of our house. This in the text of law, and the right of our letters, correspondences. So back then, in 1948, the right to privacy was something that it was tangible, like it was about protecting our house against unauthorized entry or ensuring that no one will read our letters. Mm-hmm. Our private information was really physically contained within our home, our house, or trusted institutions like the Postal Service, which was, the sole guardian of our deep secrets. When I was writing to someone, to my friend, my wife, I wrote there my, deep secrets. And we had only one institution protecting this information, private information, personal information. So if we fast forward from 1948 to our days, 2024, we have seen lots of changes, lots of new technologies. And these changes impact the concerns on who really has access to our personal information and how they have access to our personal information. Our most private information is no longer just in our house or letters. It's shared around the globe, stored by multiple companies, many of which we even don't know they are keeping and storing our personal information. We have companies today that know where we are, what we are reading, what we are buying, with whom we are talking, for how long, where we sleep. I can continue going on and on with all this personal information that is shared across the world that we even don't know. So these companies might be sharing our data with other entities as well, creating what I call a web of unknowns regarding who has access to our data and how they are using it. And I think one important thing that I want to clarify, it's not only how they are using our personal information. We also know that companies today, they are targeted by criminals that are trying to have access to our information, so our information can be leaked, can be breached, and ending up in the hands of those who can really harm us, financial or our reputations. And one last point about these whole changes. It's not only private companies that must be concerned. We also must be concerned about the power that this data, the quantity of data that we are giving to governments. Like they now have the way and the tools to monitor us, track us. It can lead to state power and control over our lives. People say I have nothing to hide, but we know that knowledge is power. So if the government has the ability to track and monitor our information, it gives power to them to profile us, to monitor dissent, and even control our actions. So given all these facts, we had the necessity to protect our individual privacy rights. And the creation of this regulation had the purpose to give us the tools and mechanisms to understand how our personal information is being collected and processed. So We need to, now companies and governments need to ensure transparency about what data they are collecting and grant crucial rights over personal data, like right to access and right to be forgotten. We may talk about it. So when we say from privacy to data privacy, that's what I want to say, that the right to the data privacy now that we have in the regulations is the expansion of the right to privacy that we had in 1948. That's it.
Amazing. Thank you, Marcelo. That was a really, really nice and in-depth description of how it's evolved over the years. And Sara, from your perspective, you have seen how the market has reacted to data privacy. You've been, working in the data privacy landscape, working for a company who has a product that is trying to solve for these problems. And how have you seen the market reaction change over the years that you've been working?
Yeah, sure. So thank you for the question. So I think that the mindset of focus has changed a lot. So when I started in the company 4 years ago, GDPR was quite new, and customers were interested in being compliant with GDPR and getting a SMB solution on their website that could help with this. And when I started 4 years ago as a legal counsel, we had around 30 people in the office, in the company, and the focus was mainly on GDPR. And the company grew insanely from day to day. And after being a part of the company for about 1 year, then suddenly we were in a merger, which was a huge step for the company to become one of the biggest players in the market, and also a huge success for all of us as employees. And I saw a bigger attention to privacy, both from our customers, but also from organizations, authorities, activists, and others. And one of the biggest milestones for us as a company was when the Digital Markets Act, also known as DMA, came into force in November 2022. And the DMA aims to promote fair and comprehensive digital markets in the EU. And by helping the gatekeepers who are required to be compliant with the DMA, it was a great opportunity for us as a company to help gatekeepers and more companies reach privacy compliance. And today we also see the big benefit of the huge success DMA actually is for our company, which is amazing. And to get back on GDPR, so during the years, we have seen an increase in data privacy awareness. And as GDPR started a global discussion on protecting individuals' personal information and the fundamental rights, individuals now have a better understanding of their rights. And this leads to a growing demand of transparency from a company like us and companies and organizations in general. And due to the higher requirements in the market and also higher requirements from our customers, the focus has shifted to going more detailed into GDPR requirements. And as things change over time, it naturally places more and more requirements on us as a CMP provider, as we want to update our product in line with market developments, requirements and legislations, but also customer requirements. So what have we changed during the last years in our mindset and and products in our company? I think here we'll say that we on an ongoing basis check our products and make sure that we have a product that enables and help being compliant with country-specific requirements on the data privacy and data protection. We need to ensure that we have a product that is up to date with new requirements and regulations as one of the first on the market to ensure that our customers feel safe and confident that we have a product that help them comply with legislation. And when we look at data privacy legislation around the world, only more and more countries and states are coming up with their specific requirements and regulations in data privacy. So I will say that the focus is only going to get higher and higher every day. And here I also want to mention that this focus also reflects in our company vision, saying that enable organizations to leverage data privacy to communicate and interact with their users and cover their online compliance. So when this is being said, and a conclusion from my side, companies have taken the first step into GDPR compliance. And now the challenge goes far beyond just being compliant, right? So not only are regulators paying closer attention to how people's data is used online, consumers are more aware than ever before about the data privacy. So what does it mean for businesses? It is a vital importance to build trust with the user base while in achieving regulatory compliance. And a consent management platform solution is an invaluable piece of the puzzle to achieve just that.
Mm-hmm. Thank you, Sara. Really interesting. I would like to dig into something that you started speaking about, that it's not just GDPR anymore. These are legislations that are popping up all over the world. You know, we're seeing them across the US and in Brazil, South Africa. A lot of places are implementing these legislations. So what have you both seen in these different legislations, and are there gaps in what we're seeing across the globe?
This is correct. It's not only GDPR and not only Europe. What we saw that is data privacy regulations are emerging all over the world. And these laws, they share common principles, but there are some differences and some gaps. Like we started to talk about GDPR. GDPR is the most, in my view, most important data privacy regulation that was enacted in recent years, because it set a high standard when it was implemented in 2018. It gives individuals control over their personal information, and it is imposing, obligations on organizations, like we said in the beginning. Following the GDPR, what we saw is really a Control-C, Control-V of the regulation in a lot of places. Like many countries have developed their own privacy laws inspired by the GDPR, but, tailored for specific legal context within the country. One example, in the United States, the first important privacy law in recent years is the CCPA, the California Consumer Private Act, which grants California residents rights over their personal information, the right to know. It's the same as the right to access, similar to a right to access, the right to delete data. But they also implemented and enacted a specific right that we don't have in GDPR, that is the right to opt out of the sale or sharing of personal information. We can also dig more in the rights, but to make it simple, like this right to opt out of the sale, if some company is collecting your email address and wants to sell it to advertisers, you can choose to say, no, I don't want you to share my personal information with these third parties, to these companies. So unlike the GDPR, which is a comprehensive regulation covering all Europe, the entire European Union, in the US, we have we have a more fragmented approach with different states enacting their own laws. And this creates a patchwork of regulations that can be very, very, very challenging to SMBs, small and medium business. We have in Asia, we see countries like Japan with the name is the Act of Protecting of Personal Information, APPI. I love the short words like
acronyms.
When we are studying privacy law, I think the most difficult thing is to remember all this. But we have the APPI which was recently amended to align with GDPR and impose more obligations regarding the breach of personal information. We have in China the Personal Information Protection Law, PIPL, which talks and put some focus on data localization obligations, kind of. And we have LGPD in Brazil. We have Pipeda, I don't know how to pronounce.
Papia in South Africa.
No, in Canada.
In Canada.
But okay, so we have it in all around the world, and while the core principles of data privacy laws around the world are similar, where they focus on transparency, control, and security, there are some differences, and these demands, we are talking here about SMBs, proactive approach to compliance, especially for, SMBs that are operating on a global scale. So if I can give a tip or a recommendation, if you are operating in a global scale, how to do it. I think the initial step or the most smart choice is to choose some strict data privacy law like the GDPR, so you can ensure broader compliance with other, but you need to continue to investigate specific and local obligations for your local market. But it's a good start to start compliance with GDPR.
Yeah. Super interesting. And something even more interesting is most regions have adopted a countrywide policy. But for example, in the US, they have gone even deeper into state level policies, making it even more confusing for what users are supposed to do. Sara, we've been looking into this as a company quite a lot, and we're really trying to understand each individual legislation. Could you give us a little bit more information on this and how this is evolving?
Yeah, sure. And thank you. This is a really good question. So I will start with saying that it's important for me to mention here that I'm not an expert in US law, right? So I focus on GDPR and EU requirements. But when we look at the US, we see that more and more states have their own data privacy law in place, or at least in the near future. But when looking into the requirements behind the state-level data privacy laws, there are many similarities, but we also see some differences. So to give you some examples here, when we look at the consent model, as Marcel also mentioned, it is in general opt-out, meaning that in many cases, a business can collect a use data subject personal data without requiring consent, but they must have the option to opt out of that. But if we, for example, take a look at the US privacy laws, for example, in Virginia and Connecticut, it is required to have an opt-in consent model for processing of sensitive data. And here it's also important to mention that what is considered sensitive data can also vary from state to state and can depend on political differences within the state. Another example of differences among the states is how the states have varying thresholds before they can apply to a business. For example, some states have significant revenue requirements before the privacy law apply to a company. And if we, for example, look at Florida, the revenue requirement is $1 billion. And in California, the revenue requirement is $25 million. And however, other states there are no revenue requirements. For example, if we look at Virginia. So here we see that whether a law applies at all can depend on a company revenue, ranging from $0 to $1 billion. So even though we are looking at the US as one market, we see different privacy laws with different requirements in each state. And I mean, these are just some examples when we look into US privacy laws. It's also important for me to mention that it is a continuing challenge for everyone in this space to be on track on all states' differences. And this brings me to the American Privacy Rights Act. And to give you some insight here, so this year, the US Congress released a version of the American Privacy Rights Act. And here we saw an opportunity to unify the inconsistencies across some states with one national law. And we were actually really hopeful that this would finally be the national law because there is an obvious need to unify the privacy issues across the states. But unfortunately, the bill has not progressed, and it seems that the bill might be dead. So looking into the future, I mean, the future is totally unknown at this point because of the political differences we see in the US on a number of topics. And as the last thing from my side here for this question, I think that we should keep in mind, as you have also mentioned, that it is not just about the privacy laws in the US, but we see several privacy laws in the world already, right? For example, South Africa, Brazil, Australia, India, and so many other countries. And for some of these privacy laws, we actually see that they have borrowed a lot of things from the GDPR. And I mean, similarities in privacy laws around the world will actually just make it easier for companies to have a proper overview of the requirements for their business. But we also see privacy laws in the world where we see differences from GDPR that can cause some challenges for companies.
Yeah, it's very interesting. And I think it's also going back to what you've both kind of said, maybe just look at one of the stricter laws and try and comply with those. And I think that when we talk about smaller businesses and smaller websites like SMBs, it's pretty difficult to ensure that you only have website traffic from one country unless you are very specialized, super niche. So you don't know where your website visitors are coming from. And Sara, as you mentioned, in the US, there are some laws that only apply for companies with a lot of revenue, but then there are some that don't have the revenue requirement at all. So at the end of the day, whether you're a large enterprise or a small website serving few customers, actually these legislations apply probably to you as well. So are the regulators actually looking at these small businesses? Have there been fines to small businesses? Is it something that we really need to worry about? Or is it something that's, they're only checking the big guys, let's not bother with it? What is I know you're both the legal experts and I know what you're going to say, but let's hear it. What is your opinion on that?
So the short answer is yes. Okay. In general, these regulations are not just for enterprise and companies, and regulators are indeed looking at small, medium business as well. So just to illustrate a little bit. So GDPR applies to any organization that processes EU citizens' data, regardless of location, as you said. GDPR compliance is mandatory for any organization that processes EU citizens' data, personal data of EU citizens, regardless if they are customers or not. So if you're only receiving visitors in your website, but is collecting data, you may need to comply with the GDPR. And GDPR, there are no threshold requirements for to comply. CCPA in the US only covers entities that do business in California, The regulation applies to entities meeting some thresholds. We talked a little bit about this. Annual revenue about $25 million. Organization that process personal data of more than 50,000 individuals, and entities that have 50% of their revenue coming from the sale of data. So you may be a small entity without $25 million of revenue, but you may process more than 50,000 pieces of data of Californian citizens. So it's important to understand who you are targeting and how much data you are processing, not only your revenue, to understand if you should comply with a specific law or not. So for small and medium business, this means that they need to be aware of their responsibilities when it comes to data privacy. Even if you are running a small blog or a small e-commerce, if you are collecting personal information like names, email address, payment information, billing details, you may need to comply with these regulations. I think it's also important to mention that regulators in general also understand that small business may not have the same resources as, big enterprises. And we see this reflection on this reflected on enforcement actions from the regulators. In GDPR, for example, they take into the account the size and scope of the data processing activities. However, it doesn't mean that small businesses are exempt from compliance. They still need to implement appropriate measures to protect personal data, provide clear privacy notice, and respect individual privacy rights. The last point, I think that based on the enforcement actions, what the regulators are focusing right now is to ensure that all business, big or small, understand their obligations and take steps to protect their customers' personal information. That's
Yeah. Okay, so let's get into a scenario. Let's say that I am starting a small business selling cupcakes. I build a website and I need to know things like I need my customer's name, email address. I am shipping these cupcakes to them, so I want to know what their address is, and I will collect their billing information or their credit card information when they make a payment on checkout. So what are the first things that I should think about doing? Do I need a privacy policy? What can you tell us? What do we need to do?
So we need three more podcasts to talk about every actions but let's try to narrow it. It is a great question. Like, if I am a small business, I want to start my business now, and I just heard from you that now I have a lot of data privacy laws around the world, and it's very complex to achieve compliance. What should I do right now? So I think the initial step, I would give three important recommendations, three initial steps. The first one is to understand what is personal information. This is the first step, because when we talk about data privacy rights and laws, we are talking about personal information. So in general, personal information can be any data, okay? Any data that it identify an individual either directly or indirectly. This includes things like names, email addresses, phone numbers, but it also covers things that are less obvious, like IP address, location data, even cookie information that can be linked to a user may be defined as personal information. To make it simple about this first step, there's two questions that you should ask to yourself, like when you are collecting data. You just open a website, put a contact form to collect data from your visitors, your clients. So does the information that you are collecting identifies a person? If it does, then it is personal information. The example is pretty clear, like full name. I see the full name, I can identify a person. National ID numbers. With this piece of data, I can identify a person only with this piece of data. The second question is the information that I am collecting right now about a person is linked to this person? If it is, so it will be considered personal information. For example, a person's hobbies, interests, activities, health, everything can be personal information. Like if I open now an account on Spotify, I will have my profile, my user ID, and I start to build, my playlist. If I look only for the music list that I build, only this piece of data, this is not personal information because it's not identifying a living person. It's a list of music. But in the moment that this playlist is linked to my profile and user ID, the list of music, my playlists, should be considered personal information because it is saying something about me, the type of music that I like, the things that I like more. So this is personal information. So we understood, I hope, what is personal information. Okay, we can have 3 more podcasts only about this definition. The second step is to understand the principle of purpose limitation that we have in all data privacy laws. What does it mean? You should not collect data that is not relevant for the process you want to do. For example, you give an example of website selling cupcakes. In the checkout page, you collect the full name, the billing details, the address, because you need to ship the cupcakes to your client's home. You should not ask his medical history because it's outside of the purpose of the selling of cupcakes. If you have a good argument to sustain this collection, it is okay, but you should think that about this principle, purpose limitation. So now the third step, we now understood what is personal information. We are thinking about purpose limitation. And we also have these two. We can do the third step, in my view, is to map out all the personal data that you are collecting. This means that you should identify what data you are collecting, how you are collecting this data, and how you are using it. So we're starting by mapping out the data. This may include, the data that your client, your visitor will actively provide to you, like in the contact form that I said, they are really inputting their answers and giving their personal information to you. You may have some information when the users interact with your website, like they are visiting, you may collect IP logs, clickstream activity. You may integrate with Google Analytics, for example, and understand which page this person visited your website. So it's not actively provided, it's provided in a passive way. And you also may collect data from third parties. Let's say you have a cupcake website, you add a members area, like allowing your visitors to log in. you may allow them to log in with the Google account or Meta account, so you receive data from third parties as well. So by mapping this out, you get a clear picture of what data you are collecting, how you are collecting it, and how you are using it. And this is crucial because it makes the next steps much more straightforward. So just to summarize, start by understanding what is personal information, embrace the principle of purpose limitation, and map out the data that you are collecting. And that's it.
Okay, and then I think we have some next steps. Sara, you want to jump in and give us some more?
Yeah, sure. So when you have, as Marcelo mentioned here, the data mapping in place, it's also important for you to create a privacy policy on your website. And it's no matter the size of the company, it depends on if you're processing personal data on your website or not. And why is it important to have a privacy policy? I mean, users need to know what is happening on the website when talking about processing of their data, here including personal data. So they, for example, need to understand what is processed, for what purpose, and what rights do the users have. So if you go into the privacy policy in more details and see what you need to include here. So first of all, you need to include the identity and contact details of you as a controller, which is usually the website owner. If you have a data protection officer, also called a DPO, you also need to include the contact details of this person. And when you have the data mapping in place, you need to make an overview of the processing activities and the purposes. And this includes any processing activities and not only through third-party services. Means, for example, the process behind newsletter sign-up. How are you using customer data, invoice data? How are you acting on social media, and what data is processed, etc. And in connection with what I have just mentioned about processing activities and the purpose behind, you also need to share the legal basis of the processing and the reasons behind it. And if you are processing sensitive data, you need to include the information about the special categories of personal data. And also a list of recipients should be included. And also, as Marcelo mentioned, that if you are using data processors located outside the EU, using databases outside the EU, information about data transferred to third countries and safeguards behind is also something you need to mention for the users. And another thing is the period for which data will be processed and stored, right? So that the users know for how long the data will be processed and for what purpose. And as I mentioned in the beginning, as an example, the users need to know how to make use of their data subject rights, right? So for example, the right to be forgotten and right to access. And the possibility to withdraw consent, for example, if users have their data consent in a cookie banner and when signing up for a newsletter, it is also important to have a process described in the policy for how to actually withdraw the consent. And users need to know about the possibilities to complain to authorities, right? So this is also something that you need to include in the policy. And last but not least, the existence of automated decision-making, if this is applicable for the website and at use, this should also be included. And when we have looked at the privacy policy, it's also important for me to mention that you need to have a cookie policy in place as well, meaning a list of cookies and trackers set on the website. And here you can link to the policy in your privacy policy or other places on your website, as long as it is visible for the users, that's fine. And then we have the content management platform, also called CMP, as I have mentioned before. So what is it? So it means a banner on your website to give the users an overview of cookies and trackers set on the website, and to give them the option to give their consent or not to cookies and trackers not necessary for the website to work. So here we need to keep in mind that a CMP is not always required, meaning that if only essential services are used on the website, then you don't need a CMP. It is also important to mention here that it is required, as I mentioned before, to have a privacy policy on your website if you are processing personal data. And this information needs to be available on your website in a transparent way when looking at the users, and it needs to be available in an easy and accessible way for users. But I also need to mention that what I have just mentioned here about privacy policy, cookie policy, and CMP, it's only privacy related, right? So it's not the full picture. There are so many other things you need on the website, for example, terms and conditions. And in some country-specific laws, it's also required to have an imprint. So there are many other things on a website you need to have in place and to keep in mind when setting up the website as a website owner.
Thank you, Sara. So actually, this sounds like a lot of things. If I'm just setting up a website to sell cupcakes, this could potentially be quite overwhelming to listen to. So what is the easiest way that website owners can really stay on top of all of these privacy needs?
It's a good question as well. What is the easiest way for website owners to comply with all these privacy needs? So first, if you are planning to open a website to launch your business, it's very likely that you'll be collecting and processing your end users' personal data. As we saw, anything from email address for newsletters and payment information for purchases, it is personal information. So in my view, one of the most important steps you can take is to find the right service provider to help you, especially when it comes to security measures. Like, this is crucial because you want to ensure that the data you collect and store is well protected. It's very, very important. I work at Wix, that is a website builder platforms that helps more than 250 million users to create stunning websites. We provide tools to help our users to comply with all the applicable laws, including privacy laws. But it's important to understand that the site owner is the one really responsible for compliance. So we at Wix and other service providers as well, we will not be able to give the site owner a stamp saying that, okay, you are complying with this GDPR, with CCPA, because at the end of the day, we don't control how you're processing your end users' personal information. You may be collecting it in a website built at Wix, but selling it outside of your website. We cannot give you a stamp that you are GDPR, CCPA, LGPD compliant. However, I can assure, we guarantee that we give our users the relevant tools and mechanisms to help them to comply with all the regulations. For example, we have guidance on how to build or to write a privacy policy tailored for the user needs, with all the points that Sara mentioned in the last point. We offer an easy-to-use tools for answering data subject requests. If you have a user, a visitor that are requesting their right to access and their right to be forgotten, we provide this as a tool to our users. It's very easy to use. We also take care of the security measures. We are encrypting all we work with encryption of all the data that is collected by our users. And we offer additional features like we help our users to collect consent from our users if this is the legal basis that you are using to process personal information, which is crucial for marketing campaigns, including the ability to request double opt-in consent. We recently built an integration with Usercentrics to help our users to manage cookie banners and obtain users' consent for non-essential cookies for tracking advertising. So it is a very important resource that we are offering in our platform. But in summary, bottom line, you should choose a very good partner so you can leverage the tools and resources to make your compliance easier. But the last point from my side is to say that staying informed and proactive about data privacy responsibilities is the real key. So this is the way that you can ensure that your website not only complies with all the data privacy laws that we talked about here in the last points, but also help you to build trust with your users. The same way that we are concerned about the use of our personal data, you should be concerned how you are protecting the personal information that you are collecting from your visitors. It's not only a legal obligation, but a moral obligation. That's it from my side.
Absolutely. It's a moral obligation. It's the right thing to do. And building trust is so essential, especially when people are so concerned about their data privacy. They're aware of it, and we have to do the right thing. Is there anything else from your side, Sara, that you would give as some advice for people building their websites?
Yeah. So what I would like to add here is that before you as a website owner can even dive into these privacy needs, it is super important to know what your website is doing and how it interacts with website users. And when you have a clear understanding on this, you should always get legal data privacy support on your end, right? So here including contract with lawyers for legal advice. And I will also recommend sitting at the forefront to check data protection authorities, especially in the authority in the country where you are located. They have guidelines, rulings, and they are also referring to the European Data Protection Board and their guidelines and recommendations, which is a good way to stay on top of all these privacy needs we have mentioned today. And another thing is to take part in webinars, and also networking is a really good opportunity to stay on top of these privacy needs and what impact these needs have on your company. And last but not least, I will also recommend you to check our articles, blog posts, white papers in Usercentrics on our website for more information about privacy topics, overviews of different privacy laws to stay updated.
Thank you so much, Sara. So I think to conclude, there are a lot of things that we need to consider when we're running our own websites. We need to be mindful and conscious of the data we're collecting, what we're doing with it. And the ways that we can do this is staying educated, staying up to date on these legislations, making sure that we understand them, and also choosing the right partners, making sure you're partnering with website builders and service providers who are compliant with these laws, who understand what they need to do and are supporting you in your business journey. So Marcelo, Sara, thank you so much for joining me today. It has been great to hear all of your expert advice, your stories, your opinions, and I think our viewers have had lots of great things to think about and also actionable ways to make sure that their websites are compliant or ensure compliance on their websites. So thank you. And thank you also to our listeners. I hope that you enjoyed this episode and I hope that you got some value out of it. And if you would like to follow the series, you can check it out on our website, usercentrics.com/consented. Thanks, everyone.
Thank you.
Thank you.